and that she noticed there was a different view in Mrs. Sneiderman's eyes when she talked about her husband and when she talked about her boss. When I specifically asked her about the prior statement that she had given, when her giving advice that things smooth out after nanny, again, she became argumentative, and when I tried to ask her those questions again, she refused to answer them, and would respond, well, that was then, this was now.
Listen, I was trying to ask Ms. Morgan, is this a clip from, you say this is something that was in a different courtroom, or is this an interview that the detective had?
This is an interview that the detective did on January 21st, 2011.
And the jury has not seen any of this at this point in time?
That's correct.
Okay. Over here, does the state have an objection? What witnesses is this going to be?
Is there going to be a witness, or is he going to publish that?
No, Judge, my understanding was from Ms. Green-Cross, I won't make sure she's not here, that as to the authenticity, that there would not be an objection, that we did not need to bring Detective Thompson back to play these roles.
And that characterization is correct, Your Honor. I would like an opportunity to review the actual statements that were placed to make sure that they are in fact inconsistent, and I won't have any objections as to whether or not they qualify as prior inconsistent statements, because what Mr. Morgan has done is that he just generally stated she wasn't agreeable, she didn't want to answer my questions, but my understanding, for it to be a prior inconsistent statement, it needs to be specifically inconsistent to the question, to the response that was given to the question while she was on the stand. And there's a lot of stuff here.
Your Honor, I provided this to the state yesterday in anticipation of this, and I understand we both were busy. I'm not criticizing the state, and I haven't a chance to go over it. But as the court is aware, and each of these, when I specifically answer the question, again, she would become argumentative, would not respond to the answer, even though I asked her, did you say this? And her answer was that this was then, this was now, every time we've asked her.
And Your Honor, this is what I would ask of the court.
Yes.
If Mr. Morgan is going to introduce a prior inconsistent statement, that he first state on the record what Ms. Citron's response was, and then second, articulate to the court how said response would be inconsistent to something that she said earlier, and I would ask that as to every statement that he intends to introduce before the court. I'm sorry, before this jury.
Anything else, Mr. Morgan?
No.
And let me just, I see the clips that are written here, Ms. Morgan. Let me make sure we're on the same page. What you want, I mean, your technician is going to be to queue up the complete question that was by Detective Thompson and the complete answer to these questions by Ms. Citron. Is that what
That's right. That's why they're labeled C1, C2, C3.
And then there's now on C2, there's no question proceeding. That's all I want to make sure I'm saying. There's no question.
Right. The question I asked her.
No, I'm saying, but in order for me to compare it, I got to know what the detective asked her before she gave the answer. You follow what I'm saying?
Yes, Judge.
Yeah, I'm agreeable with what you want to do, and we can do that, but what I need to see is the question.
It's the last, Judge, Detective Thompson, the last question on C2.
I'm looking at C2.
There's a question mark.
No. Mrs. Morgan, on C2, the first thing we have S. Citron, and there's a response. But there's no question that I can know. What was the question?
Okay.
So that's what I'm trying to articulate.
Judge, while you're trying to narrow down these clips, what specifically the impeachment goes to, and we can narrow it down, we will try with our technician to narrow it down further, is the very last question and the last response, Judge.
I agree with Mr. Morgan. What I'm saying, I'm going to allow you to do what you want to do. I'm not disagreeing with you. But I'm saying, on this clip, I see what her response is, but I don't know what the question is. That's the only thing I'm trying to say.
Judge, if you would look at the very, is she that kind of person?
On C2?
Yes, sir.
You're approaching point because all I have is her response. That's all I'm saying.
That's the question.
Oh, so this is only, oh, I see. So you only want, okay, now we're on the same page.
Yes,
so
sir.
On C2, all you want to do is play the question that Detective Thompson says on this quote, is she that kind of person that I'm trying to figure out how to word this correctly that would bend her morals or her ethics? Okay. She stay on the job. Response, no. So that's all we want on C2.
Yes, sir.
Okay.
And Judge, understood for us to be able to do that, We are going to need the evening to even work our clips down. We haven't had enough time to do it. So I understand the court's position here.
No, what I'm saying is, I'm going to let you do it.
Okay.
I just want to see what the question is, so the answers are being, that's all. Yes, you're going to be able to do this, so yes.
Okay.
I'm going to overrule the state's objection, and you're going to be, because you're going to be able to, as long as you play the question and the answer, that's fine.
Right.
Because C1, see on Mr. Morgan, now example again on C1, you had a question, answer. You can play that clip on C1.
Thank you, Judge.
On C2, now we overstate subjection. On C2, what you're telling me, you only want to play the question at the very end and her response.
That's correct, Judge. I'm just telling you that I'm going to need a couple minutes for Mr. Williams to be able to narrow that down, to take out 1, 2, 3, 4, and 5 like that.
Oh, yeah.
And we will do that.
Yeah, I'll give you time for that. Now, what about C3? Now, on C3, you have an answer from the citron, the questions in the center of the page, and then there's another answer.
We'll withdraw C3, Judge.
C3 is withdrawn, so I put that over here. What about C4?
C4.
C4 starts off with an answer from the citron, there's no question received.
We will start with the question.
Okay, so I take the top. Let me just put a yellow mark there. And it says here, quote, now did you, ... You told me that she was committed to Rusty and the marriage period. Did she just bring that up out of the blue, question mark, or did you specifically ask her and then did it respond?
That's correct.
So as long as the question is played and the answer in its entirety, I will allow on C4.
Okay. And Judge, I will need a few minutes to go over with Mr. Williams specifically as to that. We can do that. We have another expert.
Right, and Mr. Wright. Yes, and I know Mr. Pledge was talking with the other witnesses and some of the queued up. So overstate subjection, I'm going to allow you to play the answer, play the question and answer. So that's on Kelly for the record. Kelly, you're talking C1 in its entirety. C2, the last question by Detective Thompson and the answer. C4, the question by Detective Thompson and the answer by Mr. Trump.
Thank you.
Now, Mr. Moore, are you going to have a transcript or just going to words on it?
Well, depends on when we do it.
That's fine.
If we do it today, it's just going to be words only. If we get to it in the morning, I'll have a different transcript.
That's fine. Brad, the cameraman needs your assistance.
Yes, sir.
So if you could assist him on this multitasking, can I help them out? All right. We're still on record, Kelly. Mr. Clay, whose witness is going to be next one? Or did you need more time to get the show?
He needs some time to watch. We are going to ask the entirety of the interview, not the interview, but the notification. The told her, as my understanding, it was approximately 30 minutes. So, yes, sir, we will be more time.
So now, do you, I'm staying.
Yes, sir.
When do you think you'll be ready to cue that up?
Well, I guess he's probably listened for about 10 minutes right now, so about 40 minutes would be my guess. Mr. Heath,
Listening to it right now. Mr. James, he's going to be your witness, is that right?
Yes, sir.
Mr. Grover, let me confer with Mr. James on there might be a way to short circuit that a little bit.
That's fine.
If I could.
Now, Lori, is there anything else we can do right now? I mean, I heard the motion, so I want to allow Mr. Morgan to play his clips, overstate subjection, so what are we doing right now? That's all.
That's our air conditioning company, maybe?
I'm saying, now I know it's getting warmer. I won't be able to do that, but I'm going to address that issue also. As the lawyers are approaching, let me get on the phone and do this.
And this is 11 Alive's continuing coverage of the trial of Andrea Sneiderman, Day 8. In this case, I'm Jeff Hollinger. Our attorney today is B.J. Pock. He is a defense attorney and a member of the Georgia House of Representatives, a Republican from District 108, which is Gwinnett County in suburban Atlanta. We are looking now at a picture of J. Tom Morgan and along with Andrea Sneiderman. Speaking of Andrea Sneiderman, that is Andrea's parents, the Greenbergs there to the left and to the right. The woman behind them would have been someone that we have heard from today, babysitter and or nanny, who was on the witness stand. Again, we are looking for your questions. If you would like to submit some for BJ, it's jhollinger@11alive.com, or you can also contact us on Twitter at 11Hollinger, Hullinger. That is Andrea Sneiderman. We are still waiting for the word at 3:36 this afternoon as to whether we will hear from her on the witness stand or not. That is the ongoing question that has been at the forefront not only today but from the beginning of this trial. If she would be on the stand. She was on the stand during the Hemi Newman trial, and in large part it is believed that because of her testimony in his murder trial that she is here today. So we will go back inside the courtroom, and B.J. Pak will join us shortly. Jeff Hullinger now with B.J. Pak, the defense attorney who has been with us since 9 a.m. this morning. You were near the courtroom. You did not see any other defense witnesses that are to be called, correct?
That's right. And there's a bench outside the courtroom where all the potential witnesses are. And when I went up there before this last break, there were no other witnesses up there. And I saw the family of Rusty Sneiderman come out. They seemed to be solemn. I saw a good glimpse of his father, and he seemed to be very solemn and serious.
We've gotten an email from Laura Wiley, and why is it that the woman who testified from the cruise ship was not on camera? And we were asking that question as well. We don't have an answer to that. If a witness requests that she or he not appear on camera, will the judge grant that request or not?
Generally not. I mean, unless they're a minor, there's generally not a special type of treatment for witnesses. Because of confrontation clause, the defendant gets to confront their witnesses. But in this case, she was in court. It looks like just a matter of the camera not being at the right angle.
Here's an email question from a viewer that says, in any situations that you know of, BJ, can a juror ever be called to testify in a trial that they sat on?
Generally, no. I mean, that's very rare. There's actually an evidentiary rule prevents them, they disqualify them as witnesses, particularly for cases that they've sat on. And many courts have special rules about even attorneys contacting jurors without permission because of that very fact. And individual jurors' memory certainly would not be the whole picture of what happened in the jury room, so it's also very dangerous to do that.
An email from Leslie. Supposedly, Andrea was offered a generous plea deal. If she is found guilty of some or all of the charges, is the judge allowed to take into consideration that a plea was offered and rejected in determining how he will now sentence her?
No, that type of evidence is usually excluded, and you're not even allowed to comment on that in closing arguments. And the judge would instruct the jury that they should not consider anything, including any plea offers or any potential punishment or sentencing issues, in determining innocence or guilt, and only based on the evidence that's been presented in court.
How do you think people interpret this outside of the law business? Is this a cautionary tale of what can happen if you bring a third party into your marriage, that it can sort of spin out of control whether you are guilty or innocent in the matter? Is that the cautionary tale in all of this, do you think?
Well, not just the cautionary tale, but I think there are some unanswered questions that people will probably want to know about. Number one, why didn't she be completely forthright with the officers. There is a question of what happened to those
All right, Deputy
emails
Carey,
and
we're gonna
texts
take,
on her
10
phone
minutes,
during that time.
and allow lawyers to,
Fact of the
talk.
matter is, I
Lawyer
think
and,
situations of inappropriate relationship in the workplace is not something that's uncommon. I think in this case it's very rare because of the murder that occurred.
All right, Judge Adams has now stepped out of the courtroom, and the attorneys now are bantering back and forth. Are we in the midst of a break, or is the judge simply walking out to attend to some business, would you guess?
Well, since the attorneys are all standing up, I'm imagining he forgot to get something from his chamber, so he's just stepping back in to his chambers to grab something.
From Cindy Klim, an email, what's up with the jean jacket the defense keeps talking about? And that is in reference to the bartender from Greenville, South Carolina at the dance club called The Pulse, in which she had a very, very vivid recollection, in her words, of Hemi Newman and Andrea there one night dancing and fondling each other, as she said. And she described Andrea Sneiderman as wearing a jean jacket. So the defense has been putting that question to some of her friends, whether or not they had ever seen her in a jean jacket or whether she had actually owned a jean jacket. So that's why you have heard the jean jacket defense, and it has sort of popped up from time to time during the testimony in this trial.
There's always been question about the reliability of eyewitness testimony, especially for people who didn't have a very lengthy view of the subject. And so, you know, for her to remember a particular jean jacket and the defense trying to point out that her friends never saw her with a jean jacket certainly goes to the credibility of that witness, the bartender.
So we're rolling toward 4 o'clock right now. The session probably will go between 5 to 5:30, as they all have before. So the sense is that we will go into Thursday without any more witnesses to be called. What will be the game plan for Thursday in your estimation if there is nobody else to be called?
Well, it's up to the prosecution if they want to call rebuttal witnesses. But it's kind of hard to imagine because given the case that they put on at case in chief, I don't know what the defense has done that may necessitate the prosecution to call some witnesses back.
Right.
Probably if there is a rebuttal, it might be very short. If that's given, if that happens, then they rest their evidence, and this is assuming that Mrs. Steinerman does not testify. Then you go into the next phase, and all the evidence is in, and then there'll be more motion practice, meaning that defense will renew their motion for a directed verdict or judgment of acquittal, and they'll argue about that.
And Praven has just shot me an email here, and she goes, hey, maybe Andrea was wearing Hemi's jean jacket that evening. You know, there's a lot of very smart people out there. Ann says she's confused about two things, and maybe you can help her. One, Mr. Clegg today was arguing in court that the daycare worker told Andrea that Rusty had been shot. Didn't she testify in Hemi's trial that no one told her until Atlanta Medical Center? Isn't that perjury either way? Wouldn't have proven murder, but she did lie on the stand.
Not necessarily. Perjury is it's a legal definition, which is you intentionally and willfully knowing the falsehood of what you're saying. You say it under oath. So people have memory's a tricky thing. You know, people may remember things differently at different times. Something may trigger the memory. So it doesn't necessarily mean because her testimony may be a little bit inconsistent does not mean that she was intentionally lying.
Regarding the Mexican man on the side of the house, didn't earlier testimony say that Rusty had seen this individual, that he had met Hemi on at least one occasion and possibly two before this incident? Wouldn't he have recognized him, and why is the defense using this information to discredit the police investigation?
Well, you also want to, well, overall there were some problems I think the defense pointed out about the investigation, the way Dunwoody PD had handled that. It goes to the credibility of some of their witnesses and the reliability, I guess, or the credibility of the prosecution's theory. If they made mistakes during the investigation, certainly they can make an argument that you know, they could be wrong about other things.
BJ, you're going to have a hard time sleeping tonight because of the number of sirens that go by our location here during the course of the broadcast day, so just get used to it, I'm afraid.
Well, we are next to a courthouse and a police station a block away, so I can see that.
Yeah, we have had a very full bevy of emergency vehicles, certainly, that have been here over the course of the last 3 weeks that we have been in attendance under these tents outside the DeKalb County Courthouse. So now we wait for Judge Adams to come back. We don't see anybody over at the defense side right now. What does that mean? Anything?
This may be a long break. You see that Mr. Clegg has taken off his jacket coat, so maybe a little lengthy break, maybe 15 minutes or so.
What's some other thoughts that you come away with from watching this in its entirety today?
I think that the defense has tried to put quantity of witnesses, over quality. Obviously, they're clearly concerned about Ms. Citron's testimony about Mrs. Sneiderman admitting to her that there was some inappropriate relationship going on with Hemi Newman. And that's actually the central focus of the perjury charge, this romantic relationship. And also, it's an important fact related to the obstruction charge, or trying to impede the investigation charge. So they try to punch some holes in it by bringing out many witnesses, a witness after witness after witness, pointing out two things. One, they never observed, right around the time of the shooting, they never observed any kind of marital problems. And secondly, that to prove that Mrs. Sneiderman appeared very surprised at the news of the shooting, and she was grieving in the days subsequent to that. For someone, if someone knew that her husband was going to be shot, that's not a normal reaction that would come about. As a result, they're raising doubt about the government's theory.
The judge says that we're going to see some DVD clips coming up that are allowed as long as questions and answers are both played. So we are going to get ready to see from Shana Citron, the former friend of Andrea Sneiderman, who was very emotionally charged on the stand, and J. Tom Morgan, to the defense, said that when you were interviewed by police, you did not cry. There were no tears. There was not that sort of Vesuvius-like show of emotions that came flowing out of her on Thursday and Friday. That was a point of contention there. So we will see her in a different mode when she was being interviewed by Dunwoody Police, which will be a very different Shana Citron from all accounts and what we saw live in the courtroom.
The theory is that these statements, as reflected in the clips, are prior inconsistent statements, meaning she said something different outside of court. And so you saw J. Tom Morgan argue that this goes towards her credibility, and certainly she's such a central witness in the case that the judge decided to let it in. There's always a danger of relying on hearsay evidence, and the ruling is the judge said you have to play the question and the answer to make sure that you have fairly portray the entire scene instead of just taking snippets of what she said out of context.
Shana Citron, if you are just joining us or kind of don't have a real full history of what has gone on in the Hemi Newman trial last year, in part, Andrea Sneiderman is here today because of her behavior with Shana Citron. She kissed her in the courtroom, and then outside the courtroom is alleged to have threatened her about testifying. And allegedly, Andrea Sneiderman told Ms. Citron that I have to do what I have to do, end quote, after her testimony. And then, that we saw that sort of that Judas kiss, if you will, that has really resonated through the months and through people that really don't even follow trials.
Well, I think on many occasions, there's a saying that the case, you don't choose your witnesses in a case. The witnesses are chosen by the facts. So if it's a best friend, it's always dangerous, of course, to call someone so close to the defendant to the stand because they could certainly testify against what the prosecution's theory is. But it seems like they were very confident in what she was going to say, and we saw the testimony from Mr. Citron that, in fact, it was pretty damaging.
One of our viewers has contacted us via Twitter at 11 Hollinger. Andrea Sneiderman never even tried to call Rusty Sneiderman when she was told something happened. For all she knew, he could have broken his leg. Strange.
Correct. And remember, this is quite a long time ago in a confused state. A lot of things are happening. It's an event that puts many people in a very stressful situation. So what was said, when it was said, and who said it might be some of those details that you don't really pick up at the time because of the gravity of the situation. So it doesn't surprise me that there's some inconsistencies in terms of the timeline and also what exactly was relayed to the defendant and others.
Here's another question for you. Can you ask BJ why Shayna Citron and the realtor's testimony was not considered, and I have to punch up here and let it load in a little more. I'm going to guess hearsay evidence probably is filling in the blank to this question from Susie. Here we go. It's working for me now. Can you ask BJ why Shayna Citron and the realtor's testimony was not considered hearsay, but the defense witness were? In all cases, they were doing the same thing, talking about what they were told by another with no other witness present.
Generally, if, for example, Ms. Sneiderman made a statement to Ms. Citron, and Ms. Citron's on the stand, there's an exception to the hearsay rule that says that's a party opponent or an admission by the opponent. So that comes in as not hearsay. They believe that it's reliable enough, and that's testimony that should be submitted to the jury. Other people who are not testifying, there are certain established exceptions in the law that allow certain out-of-court statements to come in for the truth of what they stand for. Now, a lot of times you'll see that the hearsay statement is necessary to kind of put things in context. Why did you do something? And because someone told me to do X. If you don't have that explanation, of what that person said, you don't necessarily understand why someone would do something. So he puts it in the context. If it's used like that, it's not hearsay. Now, then again, if the defense offers a statement of Ms. Sneiderman without testifying, it's an out-of-court statement offered to prove the truth of what the statement says. So, for example, if Ms. Sneiderman said, "I'm not guilty," and J. Tom Morgan, a defense attorney, tried to call a witness to say, "She said I'm not guilty," that would be technical textbook hearsay because it's a self-serving statement, not subject to cross-examination because Ms. Sneiderman is not on the stand. So under the law, they recognize that statement as something as not reliable because it's not tested and subject to cross-examination.
Interesting. Penny has sent an email. Why didn't they take Rusty to a closer hospital than Atlanta Medical Center? That's a tough question. I'm not sure how that works. I'm not sure how emergency vehicles decide where to take those who are in a dire circumstance.
That's interesting because I think they would take them to the an appropriate level of care emergency room, and they are in DeKalb County, so it may be that that's the closest one. And obviously, we think of Grady and some other hospitals, but they may not be, rated at the right level to accept patients like that.
Here is an email that I've received from someone named Mr. Mobley. The testimony earlier stated that when Trump left the armed services, now that would be the woman who was on the cruise ship for 4 days with Rusty and Andrea Sneiderman. The testimony earlier stated that when Trump left the armed services, she went to work for the CIA. If my memory serves me correctly, that would be the reason for not showing her face. We have had a number of inquiries as to why her face was not shown, and that is a good one. From Barbara, it says, relating to the jean jacket, that was the trip that Andrea said they stopped at an outlet mall for Hemi to shop. Maybe she bought the jean jacket there, or maybe he bought it there. The mystery of the jean jacket, it has become one of the great elements of this trial that everybody's talking about.
Very interesting. Maybe the prosecutor picked up on that, and they could make that argument at closing to explain away why some of the witnesses that the defense called couldn't recall the jean jacket.
Let's see here. Some other questions that we have. Let's see here. This is from B. Hathor. Who would have told Hemi when and where Rusty would be if not Andrea?
That's a very good question. But then again, they've been work colleagues for a while. I don't think it's very... I don't think that it's out of the ordinary to say that, hey, where do your kids go to school and who drops them off? And that's the type of information that you could probably deduce from just normal conversation. But And he's right. It probably came directly from Andrea Sneiderman.
You're a defense attorney. Do you like representing white-collar crime as it relates to financial shenanigans or criminal defense? Both are certainly interesting means of law to practice. What about the challenge of doing each?
Well, there are two different types of law, and they're both challenging in different ways. In white-collar cases, I think that many times there's a reasonable explanation for that. For example, a bad business decision could explain the failure of some type of projects and things like that. And it's a little bit more of a gray area whether or not what they did was, in fact, against the law or something that they negligently did. And I enjoy the white-collar aspect of it because of it's always that gray area trying to explain to jurors that, look, if you're in that situation, it may be clear now, but at the time, with all different things going on, that it may not be clear, so as to the defendant having a requisite intent to commit some type of fraud or some type of swindle.
Well, it appears that we are getting ready for the testimony. As you can see, kind of the screen off to the side over there. Shana Citron and the Dunwoody Police Department. The judge is allowing this to happen as long as we hear the questions and the answers together. This is from Pastilla on Twitter. Why didn't Andrea Sneiderman call or text Rusty Sneiderman right away when the daycare called her? Didn't she try at all?
Well, I don't know about that. That would seem to be a logical question, and that's what someone would do, try to reach them. But I don't know what the evidence showed, and I'm sure the telephone record would show that if, in fact, that she tried that.
Dunwoody Now, which is off of Twitter and is a nice site if you are interested to know what's going on in Dunwoody these days. It has a lot of followers, and they have sent a little message to us that we had the same question about the hospital, that Northside, which is in Dunwoody, has a level 2 trauma center and is only minutes away from Dunwoody Prep. So that's one of the curious aspects of this trial and the circumstances that happened in November of 2010 that I think a lot of us are curious about, that we really don't have an answer to. Maybe we can look into that and find out tomorrow.
Certainly.
All right, so the prosecution is hovering about. District Attorney Robert James is standing with his back to the judge's chair, as you can see there, along with Kelly Stevens Hill, who gave the opening argument. And you believe that it is Mr. James who will give the closing statement for the prosecution?
I believe so. And the prosecution gets the first word and then the last word. And so after the defense's closing, you may have somebody else deliver the rebuttal portion of the closing arguments. So you'll see at least two different prosecutors delivering the closing.
Are opening statements and closing statements in something like this about the same length? I think both of them, when we began last week, went about 50 minutes, close to an hour. Is that what a closing statement will probably be in terms of time?
It depends. Opening statements tend to be shorter. Closing arguments, there is a difference between opening statements and closing arguments, because you get to infer and make logical arguments based on the evidence that's submitted. Closings tend to be a little bit longer because you go through the evidence and you also do a little bit of an explanation about each count and what elements that the prosecution has to prove or has failed to prove. So it tends to be a little longer than opening statements.
Whitney Ray off of Twitter says, hey, she didn't call Rusty once after the daycare called her. She called Hemi multiple times.
That's certainly circumstantial evidence that's not very helpful for the defense.
I mean, a lot of this is circumstantial, is it not?
Oh, yes. We don't have any direct evidence. There's no smoking gun, although the emails come pretty close as to the affair, or if there was an affair. But certainly you piece together with little bits of evidence everywhere, and you paint a picture. Now, under the law, there's really no difference between circumstantial evidence and direct evidence, and the court would instruct the jury that they should be weighed the same.
All right, one more time. Anita here says, I don't know if you got to this earlier. I wasn't listening, so we'll give her the benefit of the doubt here as we are waiting for the judge to come out. Why is it that the judge allowed Melanie White's hearsay testimony, but would not allow the defense to submit evidence that Hemi Newman was convicted as mentally unstable, thus showing that this was all in his head and he was unstable when speaking with Melanie.
The judge has wide latitude on evidentiary rulings, and he may feel that one type of evidence was way too prejudicial as compared to how probative, meaning how relevant it is to the case, and it may confuse the jury. So those are the factors he considers.
All right, B.J. Pak, thank you. Now let's go back into the courtroom.
Report in the morning. It's on a hard drive right now.
I understand. Mr. James,
Yes, sir.
objection on the record?
Since he's narrowed it down, Your Honor, I don't know that I have an objection. My initial objection, and perhaps it was inartfully stated, was there was a lot. It was scattershot. There were a lot of things that I did not believe were necessarily inconsistent, but we've narrowed it down to specific questions and specific responses. So I don't have an objection at this point.
All right. The way we're going to proceed, lawyers, we will bring in the jury at this point in time, and Mr. Morgan, I will tell you to proceed with your witness and how you want to do it. And I understand. And then after he finishes, Mr. Clegg or Mr. Morgan, or Mr. Petrie, you're going to be ready to go with what you need to do?
Mr. Grogan?
Yes.
We'll be ready.
Yes, yeah, my understanding is the authenticity of the tape is being stipulated to. Is that correct, Mr. Chairman?
I have stipulated to the authenticity, but I would like to be heard as to legal argument and also the case law as to the admissibility.
Oh, sure. We'll deal with, well, let me do this portion with Mr. Morgan first. We'll take a break and do the other issue before we go to Chief Grogan.
Yes, sir.
That's fine, sir.
All right. Let's go ahead and bring in the jury. And while they're coming in, lawyers, this is, I just want to make sure we're on the same page. Approach.
Jeff Hullinger again with B.J. Pak. Well, I'll tell you what, we are going to go back.
And Mr. James, you have what Mr. Morgan has presented, so
Yes, sir.
that's what he indicated. So if it goes outside of what you have, make your objection, and I'll turn the machine on. I'll have it turned off, I'll put it that way. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Thank you, Mayor. Thank you very much, as always, for your patience and your understanding. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You can be sitting in a seat, or you can sit in your favorite seat. Completely up to you. Thank you for your patience. Thank you for your understanding. Every now and then, we've got to take up some matters outside of your presence. Don't draw any emphasis from that one way or the other. Thank you, lawyers and parties. You may be seated. Mr. Morgan, you may call your next witness.
Thank you. By stipulation, the state and the defense have agreed that the 3 clips that we intend to play to the jury this time are 3 clips, 3 audio-video recordings done by the Dunwoody Police Department Detective Andrew Thompson of Shayna Citron on January 21st, 2011 of the Dunwoody Police Department. This time, Your Honor, we would ask for permission to play these 3 clips.
All right, Mr. James.
Well, the state doesn't object to the, well, I believe Your Honor ruled that they were admissible. I don't recall stipulating to their admissibility.
I did rule that I was going to allow them to be played over state's objection.
Yes, sir.
All right. You may play those clips as you desire, Mr. Morgan.
Yes, Your Honor.
Well, how did the relationship seem to get unusually rocky during that period of time?
They were having a hard time. They were definitely having a hard time, but not necessarily different than anybody else who has, both parents have full-time jobs and trying to figure it all out.
Right. Now, she did end up deciding to hire a nanny, or they both decided to hire a nanny. Did things smooth out after that?
Yes. I caught up with.
All right, that's clip 1.
Yes, Your Honor.
All right, you may proceed to clip 2. As agreed, well, not straight, as indicated, you can play.
Is she the kind of person that... I'm trying to figure out how to word this correctly.
No. No.
All right, that's clip 2. You may play clip 4.
Thank you, Judge.
You're welcome.
Bring that up out of the blue, or did you specifically ask her?
Oh, well, when she was telling me about Hemi, I asked her point blank if anything was going on with her and Hemi. I asked her, and she said no. I mean, we've been friends for a long time. I would think that if something was going on, when I asked her that point blank, and I've asked her probably twice now, once at that meeting, at that lunch, and then I also asked her, I think it was like the night or two before he was arrested, I asked her again, because she showed me the email that he sent her while she was in Florida or something, the one with the song attached to it. She showed it to me. I'm like, Andrea, was anything going on between you guys? And she said, no. I've asked her twice. I would have thought she would have told me.
All right. Anything else on that issue, Mr. Morgan?
No, Your Honor.
All right. All right. The defense may call us next witness.
Your Honor, may reapproach.
Sure, come on up, lawyers.
Jeff Hullinger with BJ Pack, and we are here taking some of your questions. We are really getting a lot of interesting thoughts and comments from this as we sort of jump in and out. How about the insurance issue in all of this? Has it been underplayed at all, do you think?
I think it was more central fact when there was the murder charge was there, because you recall originally this case was charged as part of a RICO or racketeering case, and the motive explained therein was this $2 million insurance policy. But this is more of a perjury trial, and the murder is not central to the elements of the offense that she's currently on trial for. So I don't think it's underplayed. It's kind of irrelevant.
You know, we have been talking about the trauma center and Atlanta Medical, why Rusty was taken to Atlanta Medical Center instead of Northside, and Matthew Jenkins off of Twitter says to me, Rusty probably needed higher care than level 2. Atlanta Medical Center is level 1, and level 1 is the highest. So that's our answer as to why he was taken there.
I guess my guess was correct.
It is. It's a very good guess. But you are an attorney as well as a member of the Georgia House, so you are a guy who doesn't guess. You just are in the know.
Well, I do know the different trauma centers,
Sure.
and Georgia probably needs more.
Yep.
And so I'm familiar with that.
Yeah, that has been certainly a point of contention among a lot of state legislators. But here we are. We are almost 10 minutes after 4 o'clock, and we have seen a lot of gatherings in front of the judge like this today. We've seen at least a half a dozen of them. We just saw some video clips from Shayna Citron with Dunwoody Police. So at issue here now is what? Where to proceed from here, or does it involve more of this sort of trial within a trial testimony that's coming off DVD and police interrogations?
I think it's the latter. Since I didn't see any live witnesses sitting outside, it may be replaying of certain clips of certain video evidence that has not been introduced.
Next play, if we can make that sort of metaphor work. I'm not convinced we can, as they break huddle and now come back toward the judge again, trying to decide maybe an option that the judge has given them.
Yes, and they huddle to discuss what to do and what the proper approach is, and they're going back for further argument. And given the fact that they're not conferring with the defendant on these decisions, it may be purely evidentiary in nature, procedural, and not really substantive.
So the remainder of the day will be taped testimony, since we have not seen any defense attorneys that have been queued up outside the courtroom at this point. So the rest of it will probably be on DVD then.
That's correct. And given the late hour, I would be surprised if the defense would want to. And should Mrs. Sneiderman decide to testify, it would be unwise to start her testimony at this late in the juncture and then put her back on the stand tomorrow.
So when will Judge Adams ask Andrea Sneiderman if she will testify? He did that yesterday.
Right before the defense rests, and the judge will ask the defense lawyers how many more witnesses or how much longer are you going to take, and they would advise him, well, we're done. We have one more thing. We'd like to confer with the client about that, and so he would inquire because he wanted to get a good handle on when the jury should get the case.
Does she have to give him an answer today? Could she delay it for another day?
Not necessarily. I think the lawyers, as officers of the court, you should answer the question. So if the court asks outside the presence of the jury, counselor, how much longer do you have, or what is the decision of your client? Does she want to testify? To put it on the record, and also to gauge how much longer the trial might last. So you could give an estimate to the jurors that when they should expect to get the case.
Ruth Ellen off of Twitter asks us, it seems that Andrea Sneiderman has a lot of freedoms for being under arrest. Cell phone in court, does house arrest allow this? Well, the house arrest ended when the murder charges were dropped. It took about 72 hours for the ankle monitor to come off and for her to be a free woman again. But once those murder charges were dropped, she essentially is a free woman and she can go about her way much as you and I can, correct?
Yes, and on top of that, remember, any kind of restrictions before trial is to assure two things. One is to make sure that the defendant doesn't commit any additional crimes while she is facing these charges, and number two, that she's not a flight risk, or she's not going to run. So those things are the only restriction, the purposes of which you grant, bond and to things like that. So having email access or telephone, things like that, shouldn't occur. As a matter of fact, she should be able to continue working if, in fact, she's employed, and all other restrictions other than her being confined to her house should be not restricted.
Susie in Dunwoody is clearly believes in the innocence of Andrea Sneiderman, and she says to us, well, I'll tell you what, we'll get to that when we come back, but she makes a point here that is an interesting one, and it is worth talking about. Well, let's go into the courtroom right now.
Good afternoon again, ladies and gentlemen. Thank you very much for your patience and your understanding. The good news is this. We're going to give you an earlier recess today than normal. That's the good news. All right, and the other good news is we're going to reconvene tomorrow. Okay? And I appreciate your patience. Don't draw any conclusions one way or the other. I want you to continue to keep an open mind. I need you to be alert and attentive and listen to everything. And actually, you've been a great jury up to this point, and I really appreciate your high level of attentiveness. Let me give you these instructions. With the assistance of Deputy Garrett, we are going to allow you to depart for today. There's Deputy Garrett, there's a note. If you could go ahead and get in position, let the note go down and to my deputy. He will pass that up to me. And if there are any other notes before I give you these instructions, while he's doing it, because he's going to multitask, I want you to listen while I give you these instructions, because I'm still going to give you these instructions, no matter what this note is. Do not discuss the case or allow anyone to discuss the case with you. Once I release you for today, do not remain upon the floor. I want you to leave and go and come back fully refreshed tomorrow. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog about this case while it is ongoing. Do not go to any location that may have been made reference to. All the evidence will come to you in the form of sworn testimony from this witness stand and any physical evidence and evidence that's introduced during the course of the trial. You're more than welcome to bring something to snack in or eat with you for tomorrow's session. Do not consume any alcoholic beverages during our lunch breaks. Deputy Garrett will return to your iPhone, smartphones, iPads, and communication device, but do not text, email, or send any communication about this case while it's ongoing. As I've indicated several times, the lawyers and the parties cannot talk or interact with you, and we will be reconvening tomorrow morning. Just stay right there for a moment. Let me read the communication that has been sent to myself. All right, I have read the written communication. I fully understand what you have communicated with me. But we are still going to have to reconvene at 9 o'clock. And I understand. I know there are challenges, and I fully understand people have responsibilities outside of being a jury member. But at this point in time, I need you to honor your commitment that we made when we interacted weeks ago to be available during this time period. All right? I've been trying to end and start at a reasonable time so that sometimes matters that can be taken up before we get together, during that break in the middle, I call lunch break, and then in the evening, because now I'm leaving, and I understand there's challenges, and I don't need to know what the challenges are, but the commitment is I need you to be on time. And I need you to do everything possible, humanly possible, to be here so that you can fulfill your civic duty responsibility in this case. All right? As I instructed earlier, do not discuss the case. Allow anyone to discuss the case with you. The times are generated so that we can move through in an orderly fashion. And I fully understand life has its ups and downs and things happen. I can't control any of that. The only thing I can control is the start time. That's why we're going to start at 9 o'clock tomorrow morning. Okay? What I need you to do is do everything humanly possible to do what you need to do what I'm asking you to do. Do not discuss the case. Allow everyone to discuss the case with you. Do whatever you need to do. You're leaving a few minutes early today. If you can't do it now, that's okay. But I need your body and your mind and your spirit physically in this building ready to go at 9 o'clock tomorrow morning. I need all of them. So the best you can, meet your obligation as best as you can. Thank you for your open-mindedness. Thank you for your willingness to obey my instructions. And I will see each and every one of you, tomorrow morning at 9 o'clock a.m. That's it. Follow the instructions, Deputy Garrett. Lawyers remain. And you can leave your notepads there in the jury room, turn them face down. Nobody's going to look at your notes but you. And we got plenty of pads for you. Notepads if you need more. And I think I gave you a new pencil sharpener at your request. So if you send out a note, I'm trying to deal with all those issues too. All right, lawyers and parties, have a seat for a moment, please. Yes, lawyers, you can approach before we go on the record.
I was just going to put
yeah, I am. I'm going to let you
on the record.
Yeah, I am. I'm going to let you do that too. Okay. Just come up for one quick second.
Oh, okay.
If you don't mind.
And something else. Yes, sir.
Jury is done for the day. The attorneys are not done. BJ Pak, where does it go now with both sides here?
Well, there was no discussion about any additional witnesses, which may include the defendant. So they have some legal discussions to talk about. And if she doesn't testify again, the prosecution has a chance to present rebuttal evidence. If they do, I don't anticipate that being very long, because I think the defenses were in fact anticipated. And then after that, there's argument on whether or not there should be a directed verdict. And after that, it's closing arguments.
So the very earliest, maybe the jury gets this case on Friday.
Yes, I think that's probably the earliest time they could get it.
When we were at
Back
the
to Judge
bench
Adams.
previously, I had indicated to you that our next witness was going to be Chief Grogan of the Dunwoody Police Department for the purpose of playing a tape that was surreptitiously made of the notification of Mrs. Sneiderman back on January 4th of 2011 that Hemi Newman had been arrested in the murder of her husband. We anticipate that on that particular tape, her initial response would have been an audible and to some extent horrifying scream when she found that particular information out, and then her response would have been, as a practical matter, she was inconsolable and it was incomprehensible to her that that had in fact happened.
Yes, sir.
She is charged in several counts of the indictment. She is charged in at least 2 counts of the indictment. She is charged in count 2 of the indictment, or of what is currently count 2 of the indictment, with concealing her knowledge of Hemi Newman's culpability in the murder of Rusty Sneiderman. She is charged in count 4 of the indictment, or actually no, it would be count, I guess actually that would be the current count 1 of the indictment. I'm looking at the old indictment, okay. What would be count 3 of the current indictment, that she never suspected that Hemi Newman was involved in the murder of Russell Sneiderman prior to December 28th, 2010. She is charged in count 7 of the indictment with committing perjury when she allegedly testified that she had no knowledge that Russell Sneiderman had been shot at the time she spoke to Donald Sneiderman prior to her arrival at Dunwoody Prep, and she is charged with making a false statement in count 5 of the current indictment when she allegedly told Lieutenant Barnes and Deputy Chief Sides in the interview of January 5th that she did not know what had happened to Russell Sneiderman at the time she arrived in Dunwoody Prep, when in fact she knew that Russell Sneiderman had been shot prior to arrival at Dunwoody Prep. We believe that the tape in question would be extraordinarily relevant and germane to each of those issues. We believe that the emotional response and the ungodly sound that she uttered when she first found out that Hemi Newman had in fact been arrested for the death of her husband would corroborate the fact that she was unaware that he had in fact committed the offense, and would go to specifically defeat those counts that I have specifically made reference to. It is my understanding that the state has objected on the basis that this would have been a self-serving declaration and is hearsay, and as such is not admissible. First off, she was not charged with a crime at the time when this statement was made, when the original sound and then whatever subsequent statement she made. Secondly, she was not aware of the fact that she was being taped. Third, absent some sort of knowledge that she would subsequently be accused of this particular kind of offense and accused of having some sort of advanced knowledge that Hemi Newman would have committed this particular crime, or absent knowledge that she would be accused at some point of lying under oath for having said that she did not suspect Hemi Newman had committed this crime prior to December 28th, there would be nothing necessarily self-serving about her statements in question. It is simply her honest emotional response to being provided with information by the police. The District Attorney's Office has introduced through the Dunwoody Police Department 3 different statements from Mrs. Sneiderman, that of November the 18th, that of November the 24th, and that of January the 5th. This is one more in a series of those statements that was, quite frankly, obtained from Mrs. Sneiderman, although at no time was it a traditional statement in the sense that there is calm, rational questioning and calm, rational answers. There are questions and answers posed, but the, quite frankly, almost hysterical nature of her response and the discombobulated nature of her response is not suggestive of any sort of trick or artifice on her part. She is just responding to information provided by the Dunwoody Police. As such, we do not believe it is in any way, shape, or form a self-serving statement. We believe it was gathered by the Dunwoody Police Department during the course of their investigation, and again, since there was no specific charge pending against her, and since she had no way of knowing that she would be charged with any particular offense, it cannot be, under those circumstances, a self-serving statement. So therefore, we have asked this court to admit that statement into evidence. It is my understanding, based on the court's ruling at the bench, that you are not going to allow that, and we respectfully object to that ruling for the record, Your Honor.
Yes, sir. Mr. James?
Your Honor, counsel is right in part and wrong in part. He is right that if said evidence were admissible, based on the state's indictment, it would be relevant. If it were admissible. However, evidence has to be relevant and admissible. And in this case, the mere fact that it's relevant makes it inadmissible. What I mean by that is it's relevant because it is an exculpatory statement, all right? And the rules of evidence do not allow non-self-inculpatory or exculpatory statements from a defendant that has not testified. What I'll do is I'll cite the federal cases, Your Honor, and as Your Honor knows, the new rules that were passed, they have stated in their body that we are to lean on 11th Circuit cases And there's a Ninth Circuit case, and there's also an 11th Circuit case that cites the Ninth Circuit case. It says, for the following reasons, we affirm the exclusion of Ortega's non-self-inculpatory statements or exculpatory statements. And I'll give Your Honor the cite. It is United States of America versus Jose, Jose, Roman, Roman, Ortega, Ortega. And the case cite for that is 203 Federal 3rd 675. It is a 2000, it is a case from the year 2000, Your Honor. This is a Ninth Circuit case. In a second, I'll cite the local case, which is the 11th Circuit case. It says, for the following reasons, we affirm the exclusion of Ortega's non-self-inculpatory statements. First, Ortega's non-self-inculpatory statements are inadmissible even if they were made contemporaneously with other self-inculpatory statements. The self-inculpatory statements, when offered by the government, are admissions by a party opponent and therefore not hearsay. But the non-self-inculpatory statement are inadmissible hearsay. And then it cites to another case. It says finding that the fact that a person is making a broadly self-inculpatory confession does not make more credible the confession's non-self-inculpatory parts, which are hearsay. Then it gets to the relevant part of the opinion, and it says, if the district court were to have ruled in his favor, Ortega would have been able to place his exculpatory statements before the jury without subjecting himself to cross-examination, precisely what the hearsay rule forbids. Thus, the district court did not abuse its discretion when it limited Ortega's ability to elicit his exculpatory hearsay statements on cross-examination. Now, the case that cites to Ortega is an 11th Circuit case, Your Honor, and it is Christopher Green versus Walter McNeil. It is a 2010 11th Circuit case, and the cite to that is, I have the Lexus site, it's 2010 U.S. District Lexus 103312. And again, it is a 2010 case. And it says self-serving statements are not exempted from the hearsay rule or any other exemption or exception, and thus inadmissible hearsay. Cites United States versus Ortega. It further states, Your Honor, that if exculpatory statements were admitted at trial, a defendant would be able to place his exculpatory statements before the jury without subjecting himself to cross-examination. Again, quoting Ortega, what the hearsay rule explicitly or precisely forbids. It says further, and it even makes this distinction, even if portions of the written statements had been admitted during the detective's testimony, possibly implicating the rule of completeness, exclusion of Green's exculpatory statements would have been proper because the statement still would have constituted inadmissible hearsay. I disagree with counsel, I categorically disagree with counsel's characterization of this audio tape. I have listened to it, and when Chief Grogan informs the defendant that Mr. Newman was the person that murdered her husband, she doesn't yell out screech. She says, "Oh no," and then says "Oh no, Hemi," and then she calls his name multiple times, and then she starts asking questions like, "Are you sure?" and things of that nature. So there is no high-pitched screech that's inaudible. She yells, she's emotional, but it's very much words that are being used, and quite frankly, throughout the entire tape, she cries, asks questions, makes statements, cries, asks questions, makes statements, and makes declarations, asks questions. I think she says something to the effect of, is it due to what I told you tomorrow, which is what is it due to what I told you earlier today, which is what I suspect perhaps counsel wants to get it in for. He says no. They go through this whole conversation. Yes, she is emotional, but she is very much making statements and declarations, and based on current case law, current established case law, and furthermore, based on the case law under old Georgia law, it would still be inadmissible. I didn't pull old Georgia cases, but this was a rule that was in place even before the new rules, Judge.
All right, Mr. Clegg, anything else for the record?
The only other thing I would note for the record, Your Honor, is Mr. James and I disagree as to what an exculpatory statement is. If somebody says, "Did you rob this bank?" and the suspect says, "No, I did not," and that is the entirety of the interview, then that is obviously an exculpatory, self-serving statement. We submit that this is not a self-serving exculpatory statement under the circumstances of the nature of this interview, because she wasn't charged with the crime. There was no indication she was going to be charged with the crime, and she had no anticipation of being charged with the crime. Absent that, I don't see, when she isn't actually confronted about her admission or isn't asked whether or not she has had any involvement in a particular crime, but is simply asking questions and being very upset and wanting to know how it is that Hemi Newman came to be arrested, I don't believe that's self-serving nor exculpatory. That is simply a fact of how she was at the time that she was conveyed this information. So I believe that the state is incorrect in saying this is self-serving, and I have nothing further, Your Honor.
All right, Mr. James, anything else for the record?
Your Honor, the only thing that I would state is I would correct Mr. Clegg. I said non-inculpatory and exculpatory. Ortega says non-inculpatory. The other case that I cited, Green, says exculpatory, but they use both phrases in the different cases. And the other thing that I would state is, you know, if it's not exculpatory, then why does he want to use it? The mere fact that it's relevant means that he wants to use it to exculpate his client based on her actions and the questions that she was asking. So I think that's well, I'll leave it at that.
All right. Anything else?
The only other thing
That's fine. Go ahead. I've sent the jury home for the night.
Yes, sir. There is her emotional tone and the nature of the actual communication being uttered by Mrs. Sneiderman speaks volumes as to the issue, leaving aside the actual specifics of what was said as to those issues that she is charged with in the indictment. Specifically, did she have knowledge that Hemi Newman committed this offense or was going to commit this offense before November the 18th, and did she suspect him before December the 28th? So even leaving aside what she said, which I do not believe was self-serving nor exculpatory, her nature and the manner in which she was communicating tends to refute the allegations in the state's indictment. So as such, it is relevant without necessarily being self-serving.
All right. Mr. James, anything else for the record?
No, sir.
All right. As I indicated, I will sustain the objection. All right. Anything else at this point in time on that issue? Yes, I'm sorry.
No, sir.
Mr. Morgan, yes, sir.
We just have something to put on the record as well, Judge, if you may.
Oh, sure. Yeah, let's go ahead and do your...
Can I just finish up?
I'm sorry. I thought you were finished. I didn't mean...
No, I'm sorry. I just wanted to note that I do not have, I don't believe, a burned copy of Grogan's notification of Mrs. Sneiderman to put into the record at this time, but we will do so tomorrow morning.
All right. Thank you,
sir.
Yes, Mr. Morgan.
Thank you, Judge. I believe it was this afternoon, Your Honor, that the defense attempted to call Sherry Easter, E-A-S-T-E-R.
Yes. I
didn't know what you were...
I'm just trying to tell him, you know, let this man in. I don't know who he is, but if he wants to come in, let him come in. Go ahead.
Thank you, Judge. If Ms. Easter had been allowed to testify, I will proffer the following. Ms. Easter was an employee at General Electric for 28 years. The entire time in the Atlanta office, she's started out in a similar position or rank as Ms. Sneiderman and worked her way up through GE until her retirement when she was 28 years old. She would have testified that it was not unusual and very common for supervisors and their subordinates to travel together, whether they're male, female, male, male, female, female. She will also testify that in her own personal experience, as well as her observations, particularly here at the General Electric office in Atlanta. Let me preface it by saying that this prosecution introduced through testimony, I believe her name was Goff, Kathleen Goff, that there's a sexual harassment policy in General Electric, and that sexual harassment policy has been introduced and is evidence before this jury, and that employees, particularly female employees, if they're victims of sexual harassment, certainly have an avenue to report. It is the state's contention that...
You mean the defense?
It's the state's contention
I'm sorry.
that this was an affair and not a stalking or a balls hitting up on a subordinate, and that if it was anything other than an affair or a romantic relationship, then Mrs. Sneiderman would report it. Ms. Easter would have contradicted that in that her own personal experience that she had been subjected to sexual harassment at the General Electric office here in Atlanta and by none other than a supervisor in human resources after consulting with other women, and she had just started there, that she was advised not to report, that if she so reported that it would certainly be detrimental to her job and to a promotion, that her observation during her 28 years at General Electric that women who did report were subjected to intimidation and possible that they were not allowed to progress as others, and it's just something that unfortunately women have to put up with.
All right, who's responding on behalf of the state?
Oh, well, Your Honor, I believe that was my witness. And while the state does not disagree with the fact that It is not uncommon for male and female coworkers to travel together, and while we don't disagree with the fact that GE does in fact have a policy against sexual harassment, Ms. Easter's testimony was, Your Honor, that she's never met the defendant in this case. I believe she also testified that she is retired from GE, so we have no idea as to when she would have had her own personal experience with a sexual harassment claim and what her own personal experience was as a result of her reporting the sexual harassment. Nevertheless, Your Honor, whatever her personal experience was and whenever it was, the state's position is it is irrelevant and it is not germane to the issue in this case. And that was the basis and the reason for our objection, and we still maintain that it will be Ms. Easter's testimony was completely irrelevant to the facts and issues in this case.
All right, Mr. Morgan, anything else for the record?
Nothing for the record, Judge, other than had we gone forward, we would have shown that that's correct. Ms. Easter does not know Mrs. Sneiderman. She does not know anyone on the defense team, that she came forward only after watching this on the news and wanted the defense team to know about what went on at GE.
Okay, yes. Anything else from Ms. Hill?
Nothing further from the state, Your Honor.
All right. And I believe, went straight there. All right. Record's made. I'll leave it at that. Anything else?
Yeah, I do have a copy of the actual notification that was made of Mrs. Sneiderman by Chief Grogan back.
Oh, you do have it now?
Yes.
Oh, wonderful.
I just need to know the number to introduce it for purposes of the record.
Yes, sir.
47? 47.
47?
That would be defendant's exhibit number 47. And again, I'm tendering this only for the purposes of the record.
I understand. So noted. Ms. Carpenter will accept that for the purpose of the record. Anything else?
Nothing from the state, Your Honor.
No, sir.
All right. And we will be in a position to continue with those witnesses tomorrow, Mr. Petrie, as planned? All right. And I believe you have the next witness, Mr. Petrie?
Yes, sir.
And then we'll deal with any other issues after that. Thank you, Mr. Petrie. All right, lawyers, we completed making the record for the evening. What I had mentioned, and if the lawyer, and you can stay if they wish, to have a, what I call a preliminary charge conference on those general things that we can talk about now, and obviously we will have a final charge conference at the appropriate time. And the reason I want to do that this evening, if the parties are still available, so that if and when the case concludes, we can have the final at that point in time, and obviously we'll always have the charge conference outside the presence of the jury, and the charge conference must precede any closing arguments that are presented both by the state and the defense. Is the state in a position this afternoon to do a preliminary charge conference?
Yes, Your Honor.
Is the defense in a position? Who's going to handle that?
I believe Mr. Petrie will be primarily handling that, Judge.
The paralegal apparently couldn't find the state's request in my office, so I might need to look over somebody's shoulder.
Well, we can. I mean, I can locate the clerk, and they can bring up what was
I think
found.
Ms. Cross said she's got a copy.
Okay.
I've got.
I have one that a copy can be made for you.
That's great.
And I can have someone make a copy, if you wish. Did you? That's fine.
That would should.
All right. Actually, it won't be. What I'm going to do, I'm going to let you have access to a copy.
Perfect.
All right. You can. I'm just going to sit right here.
Your Honor, would you entertain letting those of us in the courtroom with jackets on take them off for a few minutes while we do?
Lord, the prayer.
Jeff Hellinger joined by B.J. Pak right now.
Let's take a, as I said, we're going to take about 10, like deputy.
Your legal needs, contact B.J. Thank you. All right, you are welcome. What's been going through all of the defense actions right here? What has been going on here? What have they been to accomplish?
Well, they were trying to obviously try to paint a picture of a marriage that was doing well. by all intents and purposes, before the shooting. And if you piece it together from the point of Mr. Chalmers making the arguments on behalf of Mrs. Sneiderman about why the charges should be dismissed, it kind of makes sense, the theory that they're going after. Now remember, she's charged with hindering the investigation and lying and committing perjury. One of the elements that you have to prove as a prosecutor to show that you hindered an investigation is that knowing that something is very important, an important fact, then you destroy evidence. Okay, if you look at the charges here, they're accusing her of getting rid of some emails and text messages and call records, right? That's, for example, that she knew that somehow Hemi Newman was going to commit this crime, and that he was the one that actually committed the crime, knowing that getting rid of these things would in fact hinder the investigation. Now, that's why there's a lot of testimony about trying to refute the fact that there was any trouble in the marriage, and the reaction after she found out about the news of the shooting is very relevant to that purpose. Now, they lost the motion for directed verdict